My name is Roberta Fennell. I am 63 years old, and my stepchildren told me I married their father for his money. They said it on a Sunday afternoon in April, in the kitchen of the house my husband and I had shared for 9 years, while my stepdaughter sorted his coffee mugs into 2 piles, hers and donation, and Harold's sister sat with her hands folded on the table in a posture I recognized from church. My stepson set my blue tin filing box on the counter and slid it across to me with one finger, like he was settling a tab. "That's yours," he said. "You brought it with you. Take it." I said, "All right." Those were the only 2 words I used. For 6 months after that, they believed that was the end of it. Here is the part they did not see coming. Their lawyer drafted every page of that court submission himself, every paragraph, every exhibit, every date. 14 months later, standing in a courtroom on the 2nd floor of the John Sopinka courthouse in Hamilton, he was asked to read the opening of my husband's own will out loud. He got 7 words in. Then he set the document down on the table and sat down without finishing the sentence. Welcome to Bold Mom Stories, where women who were told to take what they came with end up deciding what everyone gets. Subscribe if this is the kind of story you needed today. I spent 24 years working at the Ontario Land Registry office in Burlington. I started in 1986, the year after my father died, and left my mother with a deed she couldn't parse and a boundary dispute she didn't know she was inheriting. I took the night course. I got my certificate. I spent 2.5 decades in that building tracing chains of title, checking property descriptions against survey plans, flagging easements and encumbrances that everyone involved had forgotten about or chosen to forget. You want to know what that work actually is? It is a highlighter and a 2-hole punch, and the patience to go line by line through documents that were designed to be read quickly and signed faster. Titles have holes in them. Deeds have errors. People assume that if something was registered 20 years ago, it must be fine. My job was to find the thing that wasn't fine. I was good at it. I trained 6 clerks before I retired in 2010, and every one of them heard the same thing from me in their first week. Read the whole instrument. If a document references a schedule, find the schedule. Don't assume it says what the cover page says it says. My husband used to tease me about it. He said I read the back of cereal boxes like they were affidavits. I told him what I told everyone. I read everything. That's the job. My husband was Harold Prentice. He died on a Tuesday in March 2024, at home, in the kitchen, age 72, his heart. He had come in from checking on the furnace and was reaching for his coffee cup, and then he wasn't. I called 911 from the same room. I held his hand until the paramedics arrived. That is how quickly a life turns. I had met Harold in October 2013. He came into the registry office. I was still doing part-time consulting work at the time, with a deed of transfer for a commercial property in Stony Creek. His plumbing supply company was acquiring an adjoining lot, and the legal description in the transfer didn't match the survey on file. The discrepancy 7 meters, which sounds small until you realize where that 7 meters sits. I found it in 40 minutes. I called him. He drove over that same afternoon. He was 62. He had sawdust on his jacket sleeve, which I thought was unusual for a man whose company sold pipe fittings. I found out later he spent most mornings on the warehouse floor because he liked the work better than the desk. He listened to me explain the boundary problem for 15 minutes without once interrupting, and at the end he said, "So, what do we need to fix? Not what do I need to do? What do we need to fix?" I was 52 years old, and I had been on my own for 11 years, and I noticed that we married on a Friday afternoon in September 2015 at Burlington City Hall. Harold wore a dark blue suit he had last worn to a retirement dinner. I wore a green dress I had bought specifically for that day. His daughter cried during the vows. I thought at the time it was sentiment. I understand it differently now. Harold had 2 children from his first marriage. His first wife died in 2008 after a long illness. His son was 41 when Harold died. His son had worked at Prentice Supply since he was 16, summers on the loading dock, then full-time after college, then floor manager, then operations manager. 25 years. Everyone in Stony Creek assumed the sign out front would one day say Prentice and Son. Harold sold the company in 2019 to a national distributor out of Calgary. And his son found out at the same staff meeting everyone else did, standing next to the coffee station, holding a clipboard. Harold told me in the truck on the way home. He could not tell his son first. He said the conversation would be too hard. I understood the arithmetic of that. When a man cannot face a hard conversation, he has it with whoever makes it easiest on him. And when his son went looking for who had changed his father, I was the person standing closest. His daughter had moved to Calgary 7 years before Harold died. She had been close to her mother, a closeness built during the 20 months she spent managing medications, driving to appointments, learning the particular rhythm of that kind of love and that kind of exhaustion. When Harold renovated the kitchen in 2017, her mother's curtains came down. I didn't ask him to do that. I liked those curtains. But I lived there, so in his daughter's account of events, the curtains were my decision. I want you to understand both of those things before you decide how you feel about what came next. The Sunday after the funeral, Harold's son and daughter arrived together. His sister came with them. She is 70 and has a precise opinion about every person she has ever met. 3 cousins stood along the far wall because there weren't enough chairs. I had made sandwiches. Nobody ate them. His son said the will was already with the lawyer, and the will was clear. He said the house had been Harold's family property for decades. He said Harold's first wife had chosen the paint colors in every room. Then he said the sentence I am going to give you word for word because it matters later. You came into this family with a blue tin box and a suitcase. We think you should leave the same way. The blue tin box was my filing box. Industrial blue hinged lid, the kind of thing office supply stores sold in the 90s. I had brought it to the house in 2015 with 9 years of my own tax returns, my land registry certificate, my pension papers, my CPP statements, the deed to my car. Harold thought it was the funniest thing he had ever seen. I told him what I told everyone. I said, all right, that is all I said. I want you to hold on to those 2 words, because 12 months later, they were the most significant thing I had said in any room in my life. Harold's sister nodded once and said she thought that was fair. She had co-signed a loan for her son-in-law in 1999 and lost a cottage near Haliburton over it. She has told that story at every Christmas since. In her ledger, anyone who arrives after the grief has already been paid stands to collect what they haven't earned. His daughter did not shout. She sat across from me with her hands flat on the table and cried steadily, and she was still the hardest person in that room to be in front of. Every sentence she said was aimed at a woman who had been standing at a bus stop in Burlington in 2008, 28 miles away, the year her mother was dying. I moved into a 1-bedroom apartment in Aldershot the last week of April 2024. $1,100 a month. Radiator heat, a window that looked at a parking structure, and beyond it a sliver of the escarpment. My land registry pension was $2,280 a month. CP adds to that. I want to be honest with you about this because I think dishonesty in either direction makes a story like this useless. I was not destitute. I was erased. 9 years of a life, and the paperwork said I had been a long-term guest. My name was not on the deed. Harold had bought the house in 2001 in his name alone, and I had never asked to be added. Asking would have looked like exactly what his sons already believed I was. My name was not on his investment accounts. My name was not on the will. My name was on one document in connection with Harold Prentice, and it was a marriage contract his lawyer had drawn up. The purpose of which, as I would understand later, was to ensure I walked out with exactly what I walked in with. I took 2 things from that house that day that weren't clothing. The first was the blue tin box. The second was Harold's old work jacket from the hook by the back door. Canvas, dark brown, a Carhartt he had worn every winter since the warehouse days. Cracked left pocket. It smelled like motor oil and coffee, and the specific cold of a February morning when you walk across a parking lot before the sun comes up. His son looked at the jacket when I put it over my arm. For a moment, I thought he was going to tell me to put it back. He didn't say anything. And here is the detail I need you to hold on to, because it comes back. The back door of that house had a gap in the weather stripping that Harold had been meaning to fix since 2016. You could feel cold air coming under it all winter, a steady low draft that moved across the kitchen floor from October to April. Harold had foam weather seal tape in the garage. He had the utility knife. He said he would get to it every autumn, and then didn't. I had learned to keep slippers on from the first frost to the thaw. Every time I went through that door, I felt that draft. I felt it the last time I went through it. That door is going to come back into this story. So is the box. Hold on to both of them. Harold's lawyer called me 4 days after I moved out. He had acted for Harold on the business sale, the estate plan, the marriage contract, their file for 15 years, the way some lawyers treat a client relationship like a parking space with their name on it. In 9 years of marriage, that man had never once called me Mrs. Prentice. It was always both names, like he was reading from an intake form. He told me the will was dated October 2009 and left everything to Harold's children in equal shares. He told me the marriage contract I had signed waived my rights to any claim against the estate. He told me the window for certain spousal applications was not as long as people sometimes assumed, and that if everyone was cooperative, the estate would settle cleanly. Then he said something I would not understand for another 8 months. He said, "There is a 6-month window from the grant of certificate of appointment for certain spousal claims. I would hate to see you spend money chasing something that isn't available to you." He smiled when he said the window. I heard it through the telephone, the way you hear someone lean back in a leather chair. I asked him one question. I asked whether Harold had ever come to see him about updating the will after we were married in 2015. There was a pause, 2 seconds, maybe 3. "Not that I recall," he said. I have spent 24 years taking information from people who were telling me what they needed the documents to say, rather than what the documents actually said. I know exactly what a person sounds like when they check a mental file before they answer. I said thank you. I ended the call. For 6 months, I did nothing. I want to be honest about why, because I think it matters. I did not wait because I was confused. I did not wait because I was afraid of a fight. I waited because Harold's son had said I married his father for money, and I had decided that the best way to prove him wrong was to touch nothing, ask for nothing, claim nothing. If I hired a lawyer, every person at that funeral would say exactly what they had already been saying. If I walked away, at least no one could say it again. That is not dignity. That is pride that has put a better coat on. I told myself it was dignity in the bathroom mirror for 6 months. I was wrong both times. My friend from the Land Registry, I had known her for 20 years. We had eaten lunch together in that building 3 times a week for most of that time, took me for coffee in October. She let me talk for 40 minutes about nothing consequential. Then she put her cup down and said, "Have you pulled the estate file?" I said, "What file?" She looked at me the way you look at someone who has forgotten where they put their own hands. "The application for certificate of appointment, Roberta. It's public record the moment it's granted. Anyone can walk in off the street and ask for it." She waited 1 beat. "You walked past that counter 3 times a week for 24 years. I knew that. Of course I knew that. I had pulled estate files for other people dozens of times over the course of my career, checking whether a property was still tied up in a deceased's estate, confirming whether a transfer could proceed. I had walked past that counter so many times I had stopped seeing it as a place I could use for myself. "I'm not ready," I said, "to read a document that has my husband's name on it and my name not in it." She stirred her coffee. "They're counting on you being too polite to look," she said. She paid for the coffee on the way out. I changed the subject before we reached the door and she let me. On the sidewalk, she said she hoped I would think about it. I did. For 2 months, I thought about nothing else and did exactly nothing. In the second week of January 2025, I finally went through the pockets of Harold's work jacket. I did it because the left pocket seam had split further along the lining and I had decided to mend it. That is all. No anniversary, no sign, no particular morning. The radiator was making its January knocking noise, and I wanted something to do with my hands that wasn't sitting with my thoughts. Right pocket. 2 receipts from a hardware store in Stony Creek, a parking stub from Hamilton General, a short pencil with no eraser. Left pocket. An envelope. White, standard business size, creased into thirds the way you fold something in a hurry and push it away. The return address was a law firm in downtown Hamilton, not Harold's usual lawyer, a different one entirely. The postmark was June 2019. Inside were 8 pages. The first was a cover letter from the lawyer, addressed to Harold personally. It said, "Further to our meeting of June 3rd, please find enclosed a draft will for your review. Please note this is a draft only and is not a binding document until executed in accordance with the requirements of the Succession Law Reform Act. Contact my office to schedule an execution appointment at your convenience." The remaining 7 pages were a draft will. Clause 4 gave 1/2 of the residuary estate to his wife, Roberta Fennell Prentice, outright. Clause 5 divided the remaining half between his son and his daughter equally. There was no signature, no witnesses, no execution date, nothing. In the margin beside my name, in Harold's block printing with a blue ballpoint pen, "Looks right. Ask about timing." Stuck to the cover letter, curled at the corner the way old adhesive loses its grip, a sticky note in a different handwriting. "Harold, no rush. Away in August. Touch base in September and we'll get you booked. DP." DP September. Harold Prentice had gone into a lawyer's office in June of 2019 and told someone he wanted to change his will. He had walked out with a draft. He had written "looks right." He had put it in his coat, and then he had worn that coat to the warehouse every winter morning for 5 years and never made the call. I sat on the floor of that apartment holding 8 pages, and I understood 2 things at the same time. My husband had tried. He was slow, and he was a coward about his son, and he was nearly 6 years too late, but he had tried, and someone had helped him be slow. I will be fair to Harold because he cannot be fair to himself now. He was not a saint. He let his son find out about the company sale at a staff meeting. He let his daughter believe I had chosen to take down her mother's curtains. He let me spend 9 years sitting 1 row back from the front of my own life. But he wrote my name in that margin. He wrote "looks right." He meant to make the call. He needed 1 more week to work himself up to it, and then another week, and then 5 years of them slipped away. And then there was no more time. I called a lawyer Monday morning. Her office was above a flower shop on King Street West, and she did nothing but estate work. I put the 8 pages on her desk. She read the cover letter. She read the sticky note. She read clause 4 twice. Then she looked at me. "Mrs. Prentice," she said, and that was the first time in 9 months anyone had called me that. "This document has no legal effect. Harold could have written it in pencil on a paper bag and it would carry the same weight. Ontario requires a will to be signed at the end by the testator, in the presence of 2 witnesses, who then sign in his presence. There is nothing here." I started gathering the pages. I had my coat half on when she asked me something in the way you ask about the weather. "Out of curiosity, do you actually know when Harold signed the will they're probating? The one currently before the court?" I stopped with 1 arm in my sleeve. I didn't know. Harold's lawyer had said 2009 on the phone, but I had never seen the document. I had never held it in my hands. 24 years of reading other people's paperwork, and I had never once looked at my own husband's will. The Hamilton Courthouse on Main Street East has a court filing counter on the ground floor for estates matters. When a certificate of appointment of estate trustee is granted in Ontario, the entire file, the application, the will, every document filed since probate, becomes public record. Any person in this country can walk up to that counter and ask for it. It costs 50 cents a page to copy. I had directed people to that counter on behalf of their lawyers more times than I could count over the course of my career. I walked in on a Wednesday morning in the 3rd week of January. I gave the clerk my husband's name and the year. She brought me a folder, an inch thick, with a rubber band around it. I carried it to the table by the window, set down my reading glasses and my highlighter, and did the thing my friend had said they were counting on me being too polite to do. I started at page 1. The application for Certificate of Appointment of Estate Trustee is a standard court form. Numbered paragraphs. Harold's lawyer had signed it and filed it in May 2024. Paragraph 3. The deceased died, leaving a last will and testament dated October 14, 2009, which is submitted herewith. I highlighted October 14, 2009. Paragraph 6. The deceased is survived by his spouse, Roberta Fennell Prentice, whom the deceased married on September 18, 2015. I highlighted September 18, 2015. I set the highlighter down. I looked at those two dates on the same page, signed by the same lawyer, filed under oath at a counter 40 feet from where I was sitting. The will came first, by nearly 6 years. I have spent enough time in document rooms to know that whenever two dates in the same instrument landed in that order, the document dated before the event, the document was meant to govern. Somebody's assumption was about to collapse. I asked the clerk for a copy of the will itself. 6 pages, blue backing sheet, the kind Harold's lawyer had used since before I knew any of them. The opening paragraph read, I, Harold James Prentice, of the City of Hamilton, in the Province of Ontario, declare this to be my last will and testament. I am a widower. I have 2 children. I read it 4 times. Harold's first wife had died in March 2008. He signed this will in October 2009, a year and a half later, at a time when I was living in a 2-bedroom apartment in Burlington and had never heard the name Prentice in my life. That sentence was not written to exclude me. It was not written about me at all. It was written by a man who had just buried his wife and wanted his affairs in before winter, which is a completely human thing to do. But Harold's lawyer had filed it. He had made it the centerpiece of the entire estate. He had built every submission on a document whose opening paragraph said, in my husband's own words, that when he wrote it, he had no wife. I took the copies and sat on the bench near the east entrance. I did not feel triumphant. I felt the way you feel when you find the break in the chain of title. Not surprised exactly, just very still and very certain. There was one more thing to check, and it was upstairs. The Succession Law Reform Act is not a complicated statute to locate. It is a provincial act, publicly available. Section 15 is a single short paragraph. I found it in the courthouse library on the 2nd floor and read it standing at the reference shelf. Section 15. Subject to Sections 16 and 17, a will is revoked by the marriage of the testator. I read it standing up. Then I sat down and read it again with my finger under the words. A will is revoked by the marriage of the testator. Not reduced, not modified, not partially superseded, revoked. Section 16 sets out the exception. A will is not revoked by marriage if the will was made in contemplation of that specific marriage. Harold signed his will in October 2009. He married me in September 2015. For the Section 16 exception to apply, it would have to appear from the will that Harold wrote it in contemplation of marrying me. He had written it to a woman he had never met. He had identified himself as a widower. He had named exactly 2 people on earth. If the will was revoked, Harold died intestate, without a valid will. Under Part 2 of the Succession Law Reform Act, where a person dies intestate and is survived by a spouse and by children who are not also children of the surviving spouse, the spouse receives the preferential share, $350,000, plus 1/3 of the residue. The children divide the remaining 2/3. I copied both provisions out longhand on my notepad. Then I confirmed the current version of the statute at a computer terminal in the building. 3 different sources. Same answer every time. Harold's gross estate had been valued in the application at just under $2.8 million. I did the arithmetic on the notepad before I left the building. My lawyer did not get excited when I came back. Lawyers who are any good almost never do. She read the 2 highlighted paragraphs from the application. She read the opening of the will. She pulled the SLFAR off her own shelf and read sections 15 and 16 in front of me without speaking. Then, you didn't file a spousal election in October. The 6-month window Harold's lawyer had mentioned on the phone dangled, really, with a smile built into the syllables. I had let it pass. Good, she said. It wouldn't have mattered. She explained the difference. A spousal election under the Family Law Act is a claim a spouse makes to take against the will. It has a deadline. It requires you to take a deliberate step, file a formal document, meet a calendar. Section 15 of the SRA is something else entirely. Section 15 is automatic. The moment Harold and I married in 2015, his 2009 will was revoked by operation of law. There is no form to file. There is no window to run out. The marriage did it, in September 2015 at City Hall on the day it happened. Harold's lawyer had spent 6 months running out a clock. He had been running out the wrong one. At our next meeting, my lawyer asked me to bring the marriage contract. I had it. Of course I had it. I have kept every document I have ever signed since 1987 in a fireproof box, which Harold considered among the funnier personal qualities I brought to the marriage. She read the contract the way I read a deed, slowly, out loud, in sections. When she reached the financial disclosure paragraph, the clause stating that each party acknowledged receipt of a full and complete statement of the other's assets and liabilities as attached in Schedule B, she turned the page. Signature section, witness lines, a Commissioner of Oaths block. Where is Schedule B? There isn't one, I said. There never was. I asked in the room and was told it was a formality. She wrote that down. Under Section 56(4) of Ontario's Family Law Act, a domestic contract can be set aside if a spouse can show the other party failed to disclose significant assets. Harold's financial disclosure was supposed to be in Schedule B. Schedule B did not exist, not in my copy, and not in the copy Harold's lawyer was required to produce from his own file. She also found one more thing. The marriage contract used the word separation 9 times. It used the word divorce 4 times. It did not use the word death once. They'll argue the contract covers everything, she said. That's the only door left open to them. It was a real door. I want to be honest about that. But read Section 16 again. For the contemplation of a marriage exception to save the will, it has to appear from the will itself, not from what Harold's lawyer remembers, not from an affidavit filed after the fact, from the will. And the will opened by saying Harold had no spouse. I built the rest of the chain anyway, because that is what 24 years of abstracting teaches you. You don't bring a court one document. You bring the chain. I confirmed the date of our marriage in the registry records. I documented the timeline from 2009 to 2015, 2019 to 2024. I put together 63 pages in the blue tin box and closed the lid. In April 2025, Harold's son did the single most useful thing anyone in that family did for me during this entire period. He demanded a formal court hearing. Most estates in Ontario are settled without a judge ever becoming involved. The trustee files the accounts, the beneficiary sign releases, the certificate notes closed. But Harold's son wanted a court order. He wanted a judge's signature on the distribution. According to what reached me through my friend, he told Harold's lawyer he wanted it on record so that, and here is the phrase that came back to me through 2 people, she can never come back on us. So Harold's lawyer filed an application for a formal passing of accounts before the Ontario Superior Court of Justice. The hearing was scheduled for June 2025. Because I was the surviving spouse, his office was required to serve me with notice. The package arrived on a Tuesday. Inside, a copy of the accounts, a copy of the application, and a 2-page consent form with my name typed at the top. A cover letter from Harold's lawyer said the family hoped I would sign and return it to avoid unnecessary expense to the estate. I sat down at my kitchen table with that form and my highlighter. 2 pages, I read every word, both pages, twice. The form said, I waived formal notice of the passing of accounts hearing. It said I waived any objection to the accounts, as stated. It said I consented to distribution of the estate in accordance with the terms of the will. I went through it a second time, looking not for what it contained, but for what it didn't. There was no release, no language saying in full and final satisfaction of all claims, no waiver of any right under the Succession Law Reform Act. No mention of Section 15, no mention of the words surviving spouse anywhere except in the caption, where the lawyer's assistant had typed my name. Harold's lawyer had pulled a form he used for adult children and put a widow's name on it. I signed it in blue ink on a Tuesday morning in May, at my own kitchen table, unhurried, 63 years old. I want to be precise about this because it is the part people sometimes get wrong when they repeat this story. I was not tricked. I was not being clever. I meant every word I signed. I did not objection to the accounts. I had no objection to the accounts. I genuinely consented to distribution of the estate under the will. I simply also knew what a revoked will cannot lawfully distribute. I read everything. That's the job. My lawyer filed her own document the same afternoon. A claim of entitlement on intestacy under the Succession Law Reform Act, Sections 15 and 46. 4 pages, served on Harold's lawyer by registered mail. The return card came back signed on a Thursday. They all came to the hearing. Harold's son in a jacket and tie. His daughter in from Calgary with her husband beside her. Harold's sister in a church suit with her handbag in her lap. 3 cousins, including one who had started to say something at the kitchen table 14 months ago, and then I looked at the floor instead. They came because Harold's son wanted witnesses. He wanted them present for the stamp that was going to settle everything. I arrived with my lawyer and the blue tin box, which I used as a briefcase because it holds 63 pages flat without bending them, and because I had decided that morning I wanted to carry it. Harold's son met me in the hallway outside the courtroom. He looked at the box for a moment too long. Something moved across his face. He had slid that box across a kitchen counter with one finger. He knew exactly what it was. He said it again. "You came with a box. You get the box." I said, "That sentence isn't yours. Your father's lawyer put it in a letter the day your father died, before the funeral was arranged. You've been delivering another man's line for 14 months and paying him his hourly rate to write it." He opened his mouth. The bailiff opened the door. The judge was in his early 60s, reading glasses on a cord, the manner of someone who has been working through estate files for long enough that nothing in a court brief surprises him. Harold's lawyer made his presentation. Clean, confident, the estate, the assets, the will, the proposed distribution. He held up the signed consent form. My signed consent form, a half-second longer than necessary. "The surviving spouse has executed a consent, Your Honor, dated May 6th of this year." My lawyer's intestacy claim was also in the file. Harold's lawyer had answered it in one paragraph on letterhead, arguing that the spousal election window had expired and the claim was untimely. He had answered a section of the Act he had not looked up carefully enough, in response to a provision whose operation has nothing to do with elections or windows. Harold's daughter turned in her seat and caught her brother's eye. He nodded once. The way you nod when something you expected to be difficult turns out not to be. Harold's sister let out a slow breath. Then the judge took off his glasses and let them hang on the cord. "Mr. Webb," he said, "your application says the certificate was granted on the basis of a will dated October 14th, 2009. That's correct, Your Honor. And paragraph 6 says the deceased married the applicant, the surviving spouse, in September 2015. Yes, Your Honor, but as I noted, the surviving spouse has signed a consent. Read me the opening paragraph of the will." The pause was 2 seconds, maybe 3. I have been counting pauses in offices and counter rooms for most of my professional life. A 2-second pause before answering a direct question is a specific thing. It is long enough for a person to understand what they are holding. Harold's lawyer picked up the will, Exhibit A, his own exhibit, a document he had typed in his own office 15 years ago. I, Harold James Prentice of the City of Hamilton, In the province of Ontario, declare this to be my last will and testament. I am a widower. I have two. He stopped. He had written those 7 words himself in 2009. He had filed them with the court in 2024. He had marked them Exhibit A in 2025, and standing in that courtroom, reading them aloud, for what I suspect was the first time since he had typed them. He heard what they said. The window unit rattled. Someone's chair creaked. Harold's son said, "What?" very quietly, to no one in particular. Harold's lawyer set the will down on the table and sat down without picking it back up. The judge put his glasses on. "Counsel," he said, looking at my lawyer. "Section 15 of the Succession Law Reform Act, Your Honor." Harold's lawyer came back up. He argued. He said the marriage contract barred any claim. He said the consent form I had signed was binding. He said, and this is where his voice went up in a register it had not reached all morning, that a party cannot sign a consent to distribution and then stand up and challenge the distribution, and that the court should not permit it. He talked for 4 minutes. Harold's son nodded at every sentence. My lawyer stood and used approximately 45 seconds. Section 15 is not a claim, Your Honor. It is a statutory operation. The 2009 will was revoked the moment the testator married in September 2015. The consent form Mrs. Prentice signed waives notice of this hearing and waives any objection to the accounts as stated. It says nothing about Title 20, nothing about the SLRA. Cannot waive the operation of Section 15 because Section 15 is not a right she holds. It is what the law did to the will the day she said her vows. As for the marriage contract, Schedule B of the financial disclosure is referenced in the instrument and does not exist in her copy or in counsel's own file copy. Section 56(4) of the Family Law Act. She sat down. That was when I stood up. Once, the only time I stood up all morning. I did not raise my voice because I have never in my life gotten what I needed by raising it. I said, "Mr. Webb, you drafted every page of every document in this proceeding. I only read them." Then I sat back down. The judge ruled from the bench, which he noted he does not usually do. He held that Section 15 of the Succession Law Reform Act applied on the face of the public record. He noted that the Section 16 exception requires the intention to appear from the will itself, and that a will whose opening identifies the testator as a widower with no spouse cannot qualify for that exception. He held that the consent form I had signed waived notice and objection to the accounts, and nothing beyond that. He held that the marriage contract was unenforceable under Section 56(4) of the Family Law Act for failure to provide required financial disclosure. He noted, dryly, that a schedule referenced in an instrument but absent from both parties' copies is not a technicality. Under the intestacy provisions of the Act, the surviving spouse receives the preferential share of $350,000 plus 1/3 of the residue of the estate, on a net estate of approximately $2.8 million. I will let you do the arithmetic. Harold's son came out of his chair. He hit the table with his open hand and said his father would never have wanted this. The bailiff moved forward 1 step. The judge said his name, twice, in a flat and level voice. Harold's daughter did not shout. She turned around in her chair and looked at me for 3 seconds. Very quietly, she said, "He told me once, in the truck, that he wanted to change it." I thought he was just talking. Then she turned back around and did not look at me again for the rest of the hearing. Harold's sister stared at the wall above the flag stand and did not move. The judge, collecting his papers, said one final thing in the same flat and level voice. "Mr. Webb, before the fee application is scheduled, I would suggest retaining separate counsel." Here is what happened after that, in numbers, because feelings fade and numbers don't. The court issued its order. I received the preferential share, plus my intestate third of the residue. The house was included in my share at the appraised value because I asked for it, and because there was no legal basis to refuse. Harold's lawyer's fee application was heard separately. He asked for a number. He received less than half. A conduct review question was outstanding at last report. I filed a complaint with the Law Society of Ontario, not about losing, but about a draft will that sat in a client's coat pocket for 5 years and 9 months while the lawyer who could have scheduled the signing never once picked up the telephone. Harold's son retained a firm in Toronto. I am told that matter is still ongoing. His daughter called me once in August. I let her talk. She told me about the truck conversation with her father, the one she had mentioned in the courtroom. She told me what those 20 months caring for her mother had cost her, which I already knew and have never once held against her. Then she asked whether I would sell her the house at the appraised value. I said no. Then I said, but you can come see it whenever you want, just call first. She said she would think about it. She has not called. I did not change my number, and I am not going to. Harold's sister sent a Christmas card in December. 2 sentences. No apology, but something underneath the sentences that might have been reaching toward one if she had known how to write it all the way out. I put the card on the mantel and left it there through January. That is as close as anyone in that family has come. I have decided it is enough, because I am 63 years old and I do not have time to wait for better. The first thing I did when I moved back into the house was not the roof. It was not the furnace. It was not the kitchen faucet that had been dripping since October. I went to the garage. I found the foam weather seal tape on the shelf above the worktop, right where Harold had left it, still in the packaging, price sticker from the hardware store in Stony Creek still on the front. I found his utility knife. Went to the back door. 20 minutes. 1 strip along the bottom rail, 1 up each side. The door clicked shut for the first time in 9 years. You can hear it from the driveway. The blue tin box sits on the shelf in my office now. Industrial blue, hinged lid, the same box Harold's son slid across a counter with 1 finger on a Sunday afternoon in April and told me to take because it was the only thing in that house that was mine. He was right about one thing. I did come into that family with a box. I also came in with 24 years of knowing exactly how to read what's inside one. If you take one thing from me today, let it be this. Being quiet is not the same thing as being dignified. The day you finally understand the difference is the day you stop waiting to be told what you're owed and you walk up to the counter yourself and ask for the file. Nobody handed me anything. I went into a public courthouse on a Wednesday morning in January, sat down at a table by the window, and read a document that had been sitting in a public file since the day it was probated. Open to anyone, 50 cents a page to copy. I read everything. That has always been the job.